interpretation of statutes. So, what are the principles or the rules of interpretation of statutes? What are the primary rules? What are the secondary rules of the interpretation of statute? We will try to discuss today, and we will also try to discuss subsidiary rules of the interpretation of statutes, and we will also try to discuss some of the concepts which are quite relevant in the interpretation of statutes. So, dear friends, to begin with, before I start on what is the interpretation, let me tell you the meaning of a statute. To put it in a simple word, statute means a written law. Now, written law can be an act of parliament, an act of state legislative body, or the rules which are framed by the government, that is executive, in exercise of the power which is conferred upon them by the statute, that is the act of parliament or act of state legislature. It can be delegated legislation, it can be notification, any form of the law that is in written form is known as statute. Often dispute arises as to what is the exact intention of those who made law, that is law making body. So, when such dispute arises in the court or before the court, then there are certain principles which help the court in reaching at correct and true legislative intent, which is to be gathered from the written piece of law, that is called statute. Why this kind of problem arises is also to be looked into, because statute is a written piece of law, and you may be aware that there are laws which are made almost 150 years ago. We also try to see as to how the need of interpreting the law arises. Since statute is a written piece of law, law is made by the legislature consisting of the members of legislative body, and there are several statutes which are made in 19th century, such as Indian Penal Code is made in the year 1860, Indian Contract Act, Indian Evidence Act, which are made in the year 1872. So, those who make the law are not available today when the question comes before the court, what exactly is the meaning of particular expression or the word used by the lawmakers while enacting such laws. It is also clear, it is also well known that the words keep changing their meaning according to changing times. Words also change when they are used in a different context. The meaning of words used by the lawmakers is also sometimes dramatically changed over the period of time, and therefore, after such long time when the court is faced with the problem of interpreting or the understanding of the true meaning of the word of statute, then court is not in a position to call upon those who made the law and to ask them as to what you really intended by using this word. Therefore, what is to be done by the court when court is supposed to deal with such issue? For that, dear friends, we have certain rules, certain principles, and the first of such principles is the grammatical or the literal rule of interpretation, that is primary rule of interpretation. According to this rule of interpretation, the statute has to be read in its literal or grammatical meaning. The words used by the lawmakers in the statute should be given their literal or grammatical meaning, regardless of the consequence or the result which may ensue after such interpretation. court is not supposed to look into what is the consequence of giving literal meaning or the grammatical meaning to the words used or the expression used in such statute. So, this is the first rule of interpretation. However, dear friends, this rule is subject to certain defects, or because of this rule sometimes the ambiguity may arise, sometimes incompleteness may arise, sometimes there may be failure of law to deal with the problem for which the law is made or the act is made or the statute is made. Therefore, to overcome with such problem, the interpretation of statute has provided another rule, that is called golden rule of interpretation or the liberal rule of interpretation. According to this golden rule of interpretation, court is entitled to modify the meaning of the word so as to advance the purpose for which the law is enacted or the statute is enacted. Sometimes a word may have different meanings, several meanings. So, court will have to exclude the meanings which are not intended and only choose the meaning which will advance the purpose or the object of the act. So, here this golden rule of interpretation empowers the court to have the liberal interpretation according to the problem, according to the need. Court is entitled to cut short the meaning or to extend the meaning. Sometimes the word may fall short of the desired result, then court may extend the meaning so as to achieve that desired result. Sometimes the meaning may go far long, so court may cut short the meaning. The ultimate object is to ensure that the intention of the legislature is to advance some problem, to remedy some problem, and therefore, this another rule, that is golden rule of interpretation, is at aid of the court. Now, again there is third rule, that is also very important rule, but I can say it is extended form or otherwise known the Haddon's rule, because there is a famous case of Haddon that took place in 16th century, and in that this rule arose, or this rule principle was laid down by the British courts, and that rule is now known as Mischief rule also, because in the Haddon's case court has, the then court has laid down 4 different principles. Number 1, when the statute, if interpreted by following first 2 rules, is falling short of the desired consequence or it is failing to achieve the object or the purpose, then in that case court is supposed to consider 4 aspects. Number 1, court will have to consider what was the mischief for which there was a general law, but the law failed to provide remedy. So, identification of mischief for which general law did not provide any remedy, number 1. Number 2, what was the actual remedy that was falling short, and thirdly, how the special law or the act or the statute which is under interpretation came into effect to remedy the situation or to deal with the problem. So, in short, these are the guidelines. There may be examples where the existing problem is not dealt with by the existing statute. So, lawmakers may come with amendments or new statutes to deal with the same problem. So, mischief, for example, to deal with the mischief of dowry, we have had the Dowry Prohibition Act, but still the mischief continued and the Dowry Prohibition Act failed to provide a effective remedy. Therefore, lawmakers came with amendment into IPC, that is Indian Penal Code, that 498A and 300B of Indian Penal Code, which provides for dowry death. These are the stringent provision so as to remedy or give justice to the victims of dowry prohibition or the dowry. So, under such circumstances, when court is supposed to interpret the Indian Penal Code, particularly provisions dealing with the dowry, then court has to look into what is the exact mischief, that is the dowry. And in order to remedy the situation, in order to give justice to the victim of dowry, court will have to modify the meaning, to change the meaning, and to accept or to reach at suitable meaning that will give remedy to the victim or do justice to the victim. So, dear friends, these are three rules of interpretation which are very important. Besides these rules, there are certain other principles. There is another rule, that is harmonious construction. This rule is self-explanatory in the sense, what is the harmony? Harmony means to bring about a kind of unanimity or friendship. Now, this rule of interpretation is applicable when a particular statute itself provides two things which are contradicting to each other. The lawmakers would have never intended to contradict themselves by providing such two different provisions in the same statute which are contradicting each other. In such circumstances, the court is supposed to have harmonious interpretation so as to see that both of the provisions, which though appear to be contradictory, should be given effect. This kind of interpretation is known as the harmonious rule of interpretation or construction. The best example of this would be Article 12 to Article 32 of Indian Constitution, that is third part of Indian Constitution, which deals with fundamental rights, and thereafter comes fourth part of the Constitution, which deals with directive principles of the state policy. Now, there are certain provisions in the directive principles of state policy which mandate or which direct the government to have the policy to uplift certain weaker section of the society by way of coming with different policies for them. Now, these kind of provisions may appear to be contradicting to Article 14, which mandate that state shall give equal protection to all citizens. When state is making a law to uplift a weaker section, other people are not given that protection or that legal protection, then these two provisions, that is fundamental right as well as the directive principles of state policy, may appear to be contradicting to each other. But here court is supposed to have harmonious interpretation so that the Constitution of India is given in effect. So, this is very important aspect. Then there comes another rule, that is called strict rule of interpretation. This is applicable generally in respect of the statutes which are providing some penalties or which are imposing some liabilities or which are dealing with some punishments, generally penal laws or the liability laws such as tax laws, Indian Penal Code, or any such legal provision which gives or provides for the penalty in respect of certain act done by anybody, any citizen or any person. In order to impose a liability upon the person who is prosecuted or who is subject to such penalty or liability under the statute, court cannot stretch the meaning of the words used in the statute. The court will have to apply the only strict interpretation, because when lawmakers has used particular term, it has indirectly excluded other things. So, court cannot expand the meaning of the word used in the penal statute so as to include those which are excluded by the lawmakers expressly or impliedly. So, this is called strict interpretation or the strict construction of the penal statute. Dear friends, besides this there are other rules of interpretation also, which we will deal in the next video. For the time being, goodbye, and if the content of this video is liked by you, kindly like, and this channel may be subscribed and the video may be shared with others, and do not forget to give your views in the comment box. Namaskar. Thank you.